Right.
Yeah, absolutely. See you. Let me know if there's anything to do.
That was, by the way, I worked on topics of corporate constitutional rights and corporate theory, and that was, quite frankly, one of the best panels I've ever seen on the topic. And also so interesting to see people who have worked so deeply on these issues hash out some of the tensions in their work in a pretty sophisticated way. And I can see that new ideas are coming from these interactions, which really excites me. And this next panel, I think, is terrific in part because it is such a timely moment to have this panel. Campaign finance is one of today's most divisive issues, and corporate money in politics is especially controversial. So I think that this panel will be enlightening and also offer different ideas on strategies for a path forward. But I think what I can say of all of these amazing panelists is that we all agree that there is a problem going on regarding money in politics. So that there is a lot of commonality amongst even groups with a number of tensions. So I want to also note that in this section, which I will be stepping in for my colleague Jessica Levinson today, that I'm going to reserve a fair amount of time for Q&A because I suspect this is a panel that you'll want to ask questions of. So let those thoughts percolate because I'll be coming to you shortly. So kicking off this panel, I thought we might start in what is many ways the beginning. 1976, Buckley v. Vallejo, the court decided that money is speech, or at least treated as speech, that corruption and the appearance of corruption is the governmental interest sufficient to justify restrictions on campaign donations, and that limits on contributions pass constitutional muster while limits on expenditures do not. So I thought we might begin at what in many ways is the beginning and ask any of the panelists who would like to weigh in on this kind of beginning question of whether the Supreme Court was correct in placing its analysis of campaign finance restrictions under the First Amendment. If so, were there other First Amendment rubrics that the court could have employed to better result? Or if not, how should we be analyzing campaign finance restrictions?
Sure. That's really starting at the beginning. So Buckley's quite unpopular through the years, through about 4 decades of campaign finance law, but incredibly durable, right? People have attacked Buckley from both ends, but it's sort of survived. I have no idea what everyone else will think on this, but I think it's right to think of campaign finance as having First Amendment implications and importance. So I think casting it inside the First Amendment to some degree is not a mistake, and I think that's partly what makes campaign finance really difficult as a constitutional issue, as an election law issue. But it also implicates lots of other things, and I think in my view, where the court's gone wrong is not giving sufficient weight to some of these other considerations. I know Rick's upcoming book kind of puts a lot of emphasis on equality, and that's something that the court has ruled out in Buckley, and I think that was a mistake. I think in defining how we think about corruption and meeting the government's interest in regulation, the court, particularly recently, has measured that too narrowly. But I think the basic decision to think about campaign finance as having First Amendment implications and importance, that's not a mistake in itself. It's really in the application, I think, is the problem.
Let me say thank you to Elizabeth and to Loyola and to Free Speech for People for putting this event together. And I taught at Loyola for 14 years, and I've been in this room. I've been in this room for a lot of faculty meetings, so I'm happy to be here under more pleasant circumstances than a faculty meeting. But it's a wonderful space to have a discussion. John Schwartz of the New York Times told me that the very first sentence you're supposed to say is plug your book. So I think that the problem with campaign finance today happened not in Citizens United, which is coming up on its 6th anniversary, but in Buckley versus Vallejo, which is coming up on its 40th anniversary, 40 years in January. So my book is timed to that deliberately because that's where the problem is. I agree completely with Michael that the First Amendment is implicated. And I think it's very unhelpful to hear this debate over whether money is speech or money is not speech. If the government passed a law tomorrow that said no one could spend any money on elections, period, I think we'd all agree that was a serious First Amendment problem, whether or not money is speech or isn't speech. I think the question is, what are the reasonable kinds of regulation that can balance the government's interests, whatever they might be, against free speech and associational rights? And the main problem in Buckley was that it started us off on the wrong conversation, assuming that the only interest that is acceptable is an anti-corruption interest, an interest of preventing corruption or the appearance of corruption. Turns out another thing that people say all the time that's not true is that money buys elections. That's just oversimplified and not supported by the evidence. The real problem is the problem of political equality. It's the problem that we have a capitalist society that allows for economic inequality. That's endemic to the system, and that's part of what makes our economy work so well. But we also have a belief in political equality, and under our current system, we allow economic inequalities to be translated into political inequalities. And so the fundamental problem is that part in Buckley that occurred 40 years ago when the Supreme Court said that the idea that you could use political equality as a reason to limit money in elections is wholly foreign to the First Amendment. And so I think we have to take that out of the equation. We have to rethink that, rethink the balance, and also recognize the First Amendment critique that there are dangers of limiting money in elections. There are dangers of censorship. There are dangers of privileging the institutional press. There are dangers of incumbency protection and of exacerbating polarization of our political system. We need to take that seriously and come up with systems that not only promote equality and prevent corruption, but that also ensure that we have robust and competitive elections.
I come at this from a different angle because I'm not a lawyer, although I watch all of these decisions and listen to these ideas carefully and with a real interest, because I am an activist working on a 28th Amendment. And when we consider Buckley, what we see at the heart of it is Lewis Powell, who only a couple of months before Richard Nixon nominated him to the Supreme Court, wrote a memorandum to his friend Eugene at the Chamber of Commerce talking about the American free enterprise system being under broad attack. And he advocated for business people to get together and essentially take over public institutions. And he cited the opportunity in the courts as one of the four places, right? Campuses and the judiciary. And he also advocated for the vilification of certain individuals like Ralph Nader and Marcia Eliade. So we look at Buckley as poisoned fruit of a poisoned tree. And we do have, or at least I, do have an extreme problem with it. And I think that as we move towards a 28th Amendment, it is the key underpinning with Velati, and that Citizens United was obviously an outgrowth of those decisions, and we take a big issue with it. So
I'm going to agree with Rick in several respects, but most importantly, my book is called Corporations Are Not People, so plug your book first. And I say that tongue-in-cheek, but in seriousness, I do want to make a bit of a defense of phrases like that. Money isn't speech, corporations aren't people. I think it's a lot more nuanced, even when used in the public debate. It's shorthand, and I think most Americans know it's shorthand. It's not that they don't get the complicated and sometimes difficult questions. What they do get is that since Buckley, all these two lines of cases, from the corporate speech line and the campaign finance line, coming together in Citizens United, have elevated corporations and money to an almost fetish-like obsession on the court at the expense of actual speech of human beings and the rights of actual people. And so to your question about was it wrong to put it in the First Amendment context in Buckley, I'd say no, it wasn't. I do agree with Michael and Rick on that What was wrong was to leave out of the First Amendment analysis the kind of balancing that I think most, well, I'll just speak for me, I guess, not most people, but I think it's reflected in our laws all over the place that the First Amendment in the election context has a balancing of things like political equality, equal rights as citizen, one person, one vote. We do it all the time. You know, we have town meeting in the town I live in New England. Everybody gets the same amount of time, and then you sit down. Is that a limitation on speech? Yes. Is it necessary for effective self-government and democracy in our town? Yes. So signs back from the polling place, you know, there's all kinds of restrictions to make government of the people work. And so I think, yes, there's definitely First Amendment implications when in campaign finance laws, but if you eliminate the political equality considerations, if you eliminate the dangers of corruption, and you simplify too much, which I think is what's happened, to the notion that spending money is the same as speech, you end up with the kind of dangerous circumstance for our country, which we now have after Citizens United.
In Buckley v. Vallejo, the Supreme Court didn't specifically take on the issue of how to treat campaign finance restrictions applicable to corporations. Instead, it first addressed that issue of corporate political spending a few years later in this case we've been discussing and referencing, Bellotti, in which the court held that the identity of the person or entity spending money doesn't change the First Amendment analysis. And the court somewhat ignored Bellotti then in some later campaign finance decisions, such as Massachusetts Citizens for Life, where the Supreme Court carved out an exception to the law prohibiting corporations from spending general treasury funds for a small nonprofit ideological corporation, and in Austin, in which the court upheld a similar law on the grounds that the law prevented corporate political spending from having a corrosive and distorting effect on the political marketplace. And then the court heavily relied on Austin and McConnell v. FEC, where it upheld the restrictions in McCain-Feingold that prevented corporations from general treasury funds on electioneering communications. And so we had this interesting path of doctrine that came after Buckley v. Vallejo and started to address how should we treat corporate political spending. After Justice Alito replaced Justice O'Connor on the Supreme Court, the court resurrected this older case, Bellotti and Citizens United. The court famously struck down Austin and part of McConnell in Citizens United, thus allowing corporations to make independent political expenditures from the general corporate treasury. That is the holding of Citizens United, at least one way to phrase it. So with that background of kind of where the campaign finance doctrine started with regards to corporations and now where we are, I wanted to hear from this panel if there's something about corporate political spending that's different in some way, qualitatively different or different from individual spending, and why is it different when corporations engage in political spending than individuals?
Sure. So I think the first panel framed a way to think about this question pretty well, which is if we're thinking about corporations' free speech rights as derivative of the individuals that compose the corporation in some sense, however you want to define it, then we ought to think about to what degree the First Amendment right of the corporation ought to be shaped to the rights that you're thinking about, the underlying individual rights. And so I think it makes sense to think about whatever legal regime, whatever constitutional law you want to apply to corporate political spending in light of that, right? And I think one of the mistakes of Citizens United is to think of the corporation as the speaker rather than digging through the corporation to think about the constituents of the corporation whose rights are really the rights at stake. And if you think about it that way, these individuals decide at this point in time to spend through their corporation rather than as individuals or rather than setting up a PAC. And it seems to me that their rights are restricted only in the sense that they can't spend in this particular way through this particular channel, as opposed to lots of other channels that are open to them. And that's why I think Citizens United, at least when it comes to the corporate speech part, bothered me a lot. I think the larger thing, and here I'll bring an election law perspective that I think probably Rick shares, which is that really the larger problem with Citizens United from the standpoint of election law is really a lower court case that followed, which is Speech Now. So really what Citizens United did, in my view, and I think Rick's view, some people disagree, was hasten at least the coming of the super PAC age, which is the kind of basic deregulation of independent expenditures. So I think people would kind of agree, disagree about the extent to which corporate spending is a problem right now and how to deal with it. But I think the people who are really troubled about what's going on in campaign finance are particularly troubled by super PACs and what's going on with respect to outside groups. And really that, in my view, came from Citizens United. And that's the larger problem that Citizens United helped cause and certainly represents. And so from my perspective as an election law person, I think a lot less about the corporate spending part of Citizens United and a lot more about the super PAC part. That's the part that really troubles me and worries me today.
Can I?
Yeah, sure,
Can I just jump in on that? Because I do worry a lot about the corporate spending part and the super PAC part. And the reason is because I think corporate spending is different, and qualitatively, quantitatively, and it almost doesn't matter what we think. The fact is, the majority of Americans for over 100 years have thought it's different and passed laws to recognize that difference. So when Citizens United struck down the McCain-Feingold law, it was a corporate spending regulation. It wasn't a general human being spending regulation. It applied to corporations and unions under the judgment of the people through our representatives, that those are economic entities and they should be in the economic sphere, not in the political sphere. That well-known progressive Justice William Rehnquist was very worried about the merging of the economic with the political during the commercial speech cases, when the build-up of corporate speech from the 70s up to Citizens United was essentially a battle between Lewis Powell, who Michele mentioned, a former Chamber of Commerce lawyer on the executive committee of Philip Morris and boards of many other large global corporations, and William Rehnquist, movement conservative from Arizona. And Justice Rehnquist dissented in almost every case, repeatedly warning about mixing the political with the economic, finally closing one of his dissents as he realized he's losing this battle, that our ancestors learned long ago that in a democracy, the economic is subordinate to the political. It's a lesson our descendants will have to learn one day again. And that is, and what he meant is of course, corporations have massive treasuries. So in the amounts of money, if you're worried about political equality, it's very dangerous. But it's also that they're not human. They don't have judgments about whether to spend money or support a candidate because they want a good environment for their kids, or because they want a good community, or because they think, education and the arts would be a good thing, or all kinds of any other reasons that all of us bring to elections. They do it, as Adam Winkler said, Professor Winkler said in the earlier panel, in order to make a profit. That is the decision about spending corporate money in elections, and that's what makes it so dangerous, I think.
And to that end, Jeff's point about they are spending money to make a profit, Professor Winkler's point that all corporate speech is commercial speech, the degree to which our current Supreme Court does not understand these very basic givens is really troubling. And I just want to, we spoke a lot this morning about Hobby Lobby, and it is just about my least favorite decision ever for, not only its hypocrisy and disingenuity, but a statement like this that I expect folks have forgotten in Justice Alito's opinion. And I quote, "While it is certainly true that a central objective of for-profit corporations is to make money, modern corporate law does not require for-profit corporations to pursue profit at the expense of everything else, and many do not do so. For-profit corporations, with ownership approval, support a wide variety of charitable causes, and it is not at all uncommon for such corporations to further humanitarian and other altruistic objectives. Many examples come readily to mind." And then he mentioned no examples coming readily to mind. And so when you think of a corporation behaving altruistically, all that we have, and particularly, just if you look in the last month, are examples of absolutely anything but that. When you look at Volkswagen, behaving in ways that are actually poisoning people, deceiving the EPA, we're all familiar with that story. That is a horrific behavior, right? Antisocial behavior, criminal behavior, and what we're talking about probably with Volkswagen are financial penalties, but they'll continue to be in business, right? Deepwater Horizon, BP, killed 11 people, spread coaxit all over the Gulf. They're back in the Gulf now. Had that been any one of us, we would be in prison. There are these different sets of rules, different kinds of justice being applied to people. So why we go out of our way to give corporations a leg up in political speech to bend policy is quite extraordinary. Many of you may know that Doug Hughes, who was the activist who peddled his gyrocopter onto the Capitol lawn in order to deliver leaflets to Congress calling for an end to this extreme corruption, was in court this morning pleading guilty, and he could be facing 9 years. So these are, misapplications of justice, and I would call upon, this community in particular. You have two callings as we see it. One is to uphold the law, but there is another which is to do justice. And how can one look at the way this system is functioning and think that it has any approximation of any sort of justice?
I'd love to give you a chance. So the question, I might be changing it slightly, but I'd love to hear your views on whether we should view corporate political spending different than individual spending, and in effect, how should we view campaign finance restrictions that apply to, and some would say, single-out corporations?
Well, I don't agree with the Supreme Court's analysis in Citizens United, although I may agree with its bottom line that Citizens United should have been able to use its treasury funds on the 90-minute anti-Hillary Clinton documentary because it was essentially a nonprofit corporation. It took some for-profit corporate money. There were lots of ways that the court could have found for Citizens United without actually destroying Austin. And I do think, given the unique ability of corporations to accumulate wealth, limited liability, perpetual life, we all would love those things. Given those things, I think you could draw a principal distinction and impose additional limitations on corporations compared to individuals, just like we have rules that, as was mentioned in the last panel, rules that limit what contractors can do. There are rules in some states that limit what lobbyists can do in relation to campaign finance. There are rules in certain states like New Jersey that limit what gaming interests can do, where there are particular dangers. So I think singling out makes sense. But I think the broader point is this. If tomorrow Justice Kennedy had a change of heart, and I have absolutely no reason to think he's had a change of heart, nor do I expect he ever will have a change of heart. But if he had a change of heart, say, you know what, I had something different for breakfast, I'm going to overrule Citizens United, and just takes his vote to do it. Not much would change with our politics, the things that bother you. Because if you look at, corporations are spending almost no money through. First of all, corporations still cannot make contributions directly to candidates. The Supreme Court hasn't struck that down yet.
They can in California.
That could still happen, right. But I'm saying in terms of federal elections, corporations have given very little, for-profit corporations have given very little money to super PACs. Some money is now coming in through non-disclosing 501c4s and c6s, and we're not sure how much. We know Aetna and some other agencies have. But the main problem is not Google or General Motors, or the AFL-CIO for that matter. The main problem is Sheldon Adelson and Tom Steyer, who had the ability to spend the money from Buckley. Again, the problem is Buckley, 40 years ago, that said you cannot limit an individual spending on elections. And thanks to, as Michael said, the ruling on in the Speech Now case, which didn't go to the Supreme Court, which allowed for super PACs, rather than the ad saying paid for by Sheldon Adelson or paid for by Tom Steyer, it'll be paid for by the name of a super PAC, which somewhat shields this. The main problem, Justice Scalia said in his dissent in the Austin case, which had upheld the corporate spending limits, he said, one might ask, why is it okay for the individual billionaire to spend whatever he wants on elections? Why are we just limiting corporations? And he was making the rhetorical point to say we shouldn't limit corporations. I would flip it around and say, yeah, why do we allow the billionaire to spend unlimited sums? And so the problem is not, citizenship may have all kinds of terrible implications for corporate law. I'm not a corporate law person. I can't speak to that. I leave that to the rest of you who are corporate law people. But in terms of election law, in terms of campaign finance, the main problem is wealth, not corporate wealth when it comes to campaign finance.
Yeah, I appreciate hearing a variety of views on that, in part because it's so hard to measure how much corporate political spending is going on, in part because we don't have entire disclosure laws, as the previous panel was pointing out. So in some ways, it may be arguable how much of an impact Citizens United is having, and there are scholars who work on those issues of trying to measure the impact, and there isn't consensus on that point. But what I hear that's quite interesting is that Citizens United may be a problem, there is an impact, and there's also another problem, which is also wealth in having an impact in the election. So I wanted to ask you a question,
Can I say one thing about your
Sure.
question, which is that I thought Justice Stevens in his book addressed the issue of corporate speech in elections quite elegantly, which was to simply say that if you do not have a vote, you should not have a voice. And he advocated against corporate participation for that reason. You know, they have all kinds of other things that they might do, lobbying and policy and all of that, but that's one way that we could really dial down their impact, advertising-wise especially.
So I want to jump off of something that Professor Hasen said in the previous comment about if Justice Kennedy woke up and decided he would overturn Citizens United. I think many of us might agree that would be a start towards the right direction, but it might not solve all of the problems in election law and money in politics. So maybe the court isn't the entire solution. It may be part of it, depending on where you stand. But I wanted to challenge this panel to think and evaluate other options. So should we be looking to federal agencies to help limit the influence of money in politics? Is there any hope of action from the FEC this election cycle? The chairwoman has repeatedly called the agency toothless. The chairwoman of the agency herself has said that. But as it seems, the FEC is unlikely to act, what could state agencies do, perhaps, to try to limit the influence of money in politics? For instance, California's Fair Political Practices Commission has just proposed new regulations dealing with coordination. Are there proposals we should be looking at the state level? And perhaps there are other agencies, thinking both about federal and state level, maybe the IRS. What could the IRS do? And what about the SEC, the Securities Exchange Commission? What are other pathways to perhaps seeing some change in this area?
Well, I'll say that in terms of this election, I would write off the Federal Election Commission. I would write off the IRS. The SEC, if it moves, and it's been asked to move, would lead to increased disclosure, but it's not going to make a fundamental change. The FEC has been deadlocked along partisan lines, although that's a little misleading. It's not as though the Republican commissioners are voting for Republican candidates when they're challenged. It's that the Republican commissioners are voting for deregulation and the Democratic commissioners are voting for more regulation. It used to be that it took 4 votes on the FEC to get anything done. Now you get an advisory opinion with 4. That was kind of a safe harbor. Okay, you're allowed to do this, you're not allowed to do this. Now that the FEC is deadlocking 3-3 so much, campaign lawyers are treating that as a safe harbor too. That is when there's deadlock. The claim is, well, if the FEC can't figure it out, I can probably do it because nobody agrees whether it's legal or not. So much of the things that Congress tried to do in the McCain-Feingold law have been thwarted by deadlock at the FEC. At the IRS, where there could have been more stringent regulations about what 501c4 social welfare organizations could do, these are the organizations that have gotten very involved in politics, but unlike super PACs, do not disclose their donors. It turns out that when the IRS was investigating some of these groups a few years ago, they singled out for potential investigation groups that had the word Tea Party or similar words in their names. This has led to a firestorm. This has led to a deadlock in Congress. over the IRS. The IRS has now announced it's not doing anything before the 2016 election. So there's nothing going to happen with the IRS. There's nothing going to happen in Congress. Republicans in Congress seem very happy with the status quo. It used to be that Mitch McConnell, the Senate Majority Leader's mantra was more just instant disclosure, no limits. Now that we have no limits, it's no disclosure. So the goalposts have moved. There's no movement in Congress. States have no authority over federal elections, so we're not going to have that. The FPPC does a very good job in California elections, but it can't do anything in federal elections. I think if we think beyond 2016, in the near future, what we need is experiments like small donor public financing, multiple matches. We need campaign finance vouchers, which Seattle is starting with. We need to level up. We need to create a more level playing field, although God forbid that you say that, because if the Supreme Court gets a whiff that you're trying to do something to promote equality, they're going to strike it down. And longer to medium term, the best solution, we need to change the Supreme Court. That's the easiest way to amend the Constitution and change the rules, is we need to have a president who's going to appoint new justices who are going to have a different view. By January 20th, 2017, when the new president, the 45th president, takes office, 4 justices on the Supreme Court will be over 80. The chances that most of them stay on the court for the next 8 years, just speaking actuarially, is quite slim. And so there will be an opportunity. This is the chance for a generation to make a change.
If I may, I have a slightly different perspective on the last point. I do agree that the problem is Citizens United and Buckley. The problem is super PACs, big money, whether it's Sheldon Adelson or Exxon. There's no question, though, corporations are funneling massive amounts of money into our elections and into our government system. You need only look at what the Chamber of Commerce spends every year in an election. Where does the Chamber of Commerce get the money? I'll just leave that there. They don't have a revenue source. They get grants from corporations. The Republican Governors Association had a mistake with their website and accidentally inadvertent disclosure. The list of donors that they had to spend massive amounts, millions and millions of dollars in the 2014 election was exposed. And it was Pfizer, Walmart, Microsoft, virtually the Fortune 100 were all there with millions of dollars. And the only reason we haven't seen it with the Democratic Governors Association, I'm sure, is they have better coders, because it's not, same thing. Those entities have a lot of money and they get it from corporations and other entities. So it's hard to put a number on because it's so opaque, it's so much dark money, but the Chamber has spent $1 billion on lobbying since 1998, and lobbying doesn't mean, writing thoughtful, persuasive pieces. It means threatening negative attacks the next election if the person doesn't go along, and, backing candidates and incumbents when they do go along with the Chamber agenda. So I think we have to look at both problems of the super PAC and the individual money and the corporate money, and I'd say more than money, which gets me to the last point. I think in terms of your question about what solutions are from here, I agree. Not only is it ineffective to go to the IRS and FEC, those kind of solutions aren't responsive to what the country either needs or wants. To say that don't worry Americans, you all agree, it's like 80% agree that this problem has to be fixed, Citizens United should be overturned. Don't worry, the IRS is coming, is not reassuring or helpful to democracy. I think, to be honest and recognize what we face, someone in the earlier panel said a power struggle. We face a fork in the road, and it's a constitutional fork. One road is plutocracy, where money and corporations have rights, and the other road is political equality and a focus on what human rights are actually at issue in particular cases. And that doesn't mean this is a magic road with nirvana. There's still a lot of hard questions, but that question is teed up. And so I don't think, and it's teed up by a constitutional amendment campaign, it's teed up with really creative and sound jurisprudence. I think the jurisprudence from Rick and Michael and many others has built what the jurisprudence will be when Citizens United is overturned. And it's not, and it's a much richer and more thoughtful jurisprudence than the kind of, don't pay attention to the man behind the curtain pronouncements that Justice Kennedy had in Citizens United, just these announcements that independent expenditures don't corrupt, or that Americans won't lose faith in democracy, a series of announcements that I think shows the fragility and brittleness of the sort of Buckley Citizens United jurisprudence. So the question really is how we get there, and I think this is a historic moment to seize, not with small answers about the IRS, but with grand moments of confrontation with the court that has gone off the rails to fix it. And it's what we've done in our history before, and there's no reason we can't do it again. And by that I mean amendment and jurisprudence, and just not accepting that we have to live with this. The departure I have with Rick on the Supreme Court strategy, though, I think is important. And I just say a second on that. That strategy depends on Democrats winning. And right now, literally, we have 80% of Americans who agree that on the jurisprudence we want, and that Citizens United must go. Bloomberg had a poll last month. It was the same as the polls have been for 5 years. This one had Republican support for overturning Citizens United at 80%. So to take this and drive it into the existing hyper-partisan, broken system by saying, let's just double down and get more partisan for Democrats because we have to get a Supreme Court candidate, will be self-defeating, because we might pull it off and have a 5-4 for a couple of years, but we will lose this opportunity to rebuild the fabric of American citizenship, and frankly a can-do, which we've done 27 other times, to stand up when the country needs an amendment and fix it. So I think it's not sort of Pollyanna, this is easy, but I think it would be a big mistake to tell people it can't be done, this won't be overturned, try other things. I think that we have to insist to ourselves it can be done, and we're going to do it.
Can I ask a follow-up question?
I want to hear from Professor Kang, too. Yeah.
You can go ahead.
I just want to ask you about, you mentioned lobbying. You talked about lots of money spent on lobbying. Do you think that corporations should be, and constitutionally can be, limited in how much they lobby as opposed to how
That
much
was
they
one of my
spend on-
questions.
Oh, great.
Should have looked at the list, I'm sorry.
No, I think like a lot of this debate, it's about terms. So when we talk about speech, do we mean speech or do we mean money? When we talk about speakers and voices, do we mean humans or do we mean corporations? And I'd say when we talk about lobbying, do we mean visiting your congressperson, or if you're a corporation, visiting your the congressperson who represents your district or is on an important committee to bring facts and important issues to that person's attention? Of course, that's not only protected, it's critical for good policy making. But when people say lobbying today, they don't mean that. They mean what one senator told me, where he's in his office, they get a visit from the lobbyists who pull up on the computer the attack ad that's going to be running against them in the next election, and they say, we just wanted to warn you about this. I hope it doesn't happen. We're really close to being together on this position, and we're sorry we can't get agreement with you on this. But I'm sure if we could, this ad won't run. It's kind of like the old visit from the leg breaker. Nice house you have here. You'd be ashamed to lose it, wouldn't it? And that's what lobbying is today. It's not just bringing information. It's bringing information coupled with millions and millions of dollars that are driven into the election system, so that it's not a practice of trying to persuade based on facts. It's a combination of threat and reward, which undermines the very political equality and kind of civic effective democracy that I think we want. So when I say lobbying, that's what I mean, and I think that's what the chamber means when they spend $1 billion in a little over a decade on lobbying. It's not a whole lot of position papers. It's surely some position papers, but it's also that combining it with campaign spending that makes it a problem, in my view.
Professor Kang, thoughts on pathways forward, whether it's agencies, amendments, other strategies, and whether you think there can be limits on political lobbying that might be an interesting path forward as well, and if there's reasons to distinguish between political lobbying and other activity.
So a bunch of different things. I think on lobbying, campaign finance, election law people tend to focus a lot on campaign finance law. We probably know more about campaign finance law than lobbying law. There's more campaign finance law than lobbying law. But really, you can make a decent case that lobbying is more important. That campaign finance is really a lever for lobbying, and a lot more money is spent on lobbying than campaign finance. So it's neglected, and I think a lot of us are turning toward lobbying because the pathways for change on campaign finance are pretty blocked off, as Rick was saying. And so lobbying may be a way of regulating the effect of money, even if it doesn't stop the money from coming in. It's not clear that the constitutional kind of playground is any better when it comes to lobbying than it is on campaign finance. But certainly there's been less written, and the court's decided a lot less when it comes to lobbying. To kind of loop back to a couple other things, I think when Jeff was talking about corporations spending money in politics, I think he's right. I mean, so we don't know just how much corporate money is out there, and part of it's a disclosure problem. When you're talking about just individuals and tax, you could always, at least in theory, trace the money back to someone who gave the money to something else. When you're talking about for-profit corporations, that's not necessarily true. So it's really harder to sort out where the money is coming from, and if there's some source, an individual who's giving money to a for-profit corporation that also has other revenue streams and then makes makes an independent expenditure, or at the state level a contribution, the disclosure problem gets worse and worse, and it's a difficult one. I think when we talk about super PACs versus corporate spending, it's not really that election law people don't worry about corporate spending, but we have a better fix on super PAC spending right now, and a lot less of a sense about the corporate spending. There's also reasons to think that at least some corporations are not as interested in spending, at least the big Googles and Microsofts of the world, that there's some cost to the political spending that they don't really want to bother with, at least some of the time. But it's not to say that we don't worry about that, but I think we tend to worry a little bit more about the super PAC problem right now. One effect of this kind of regulatory stasis that Rick's talking about, that the FEC, the IRS, the SEC, Congress, certainly the court's not going to allow any regulation through, any new regulation through, that goes beyond what we have now. One effect of that is that Citizens United was a very clear signal to everyone, lower courts, campaign finance lawyers, regulatory agencies, about the direction that they expect campaign finance law to go. And it's kind of a Wild West in which there's no police to tell people what they can't do. And so people tend to push the rules, and it's led to a different culture, I think, in the campaign finance world, that lawyers think that they can get away with more, and they're pushing the limits more than they have. And donors think it's pretty cool to be able to do that and flex their muscles. And so I think Citizens United, other people have made this point too, I think, reflected a kind of culture shift on all these levels that's as important as the legal change itself. What can happen at the state level? One problem is that you're not really going to work your way around Citizens United or Speech Now to the degree that you think that sort of controls nationwide, because it's U.S. constitutional law, right? So the state law's got to comply with U.S. constitutional law. That said, at the state level, you could imagine state authorities figuring out problems that the federal system just doesn't have the capacity right now to figure out. For instance, coordination, right? So I think everyone acknowledges that we need to have some definition of coordination. I think actually there are campaign finance lawyers who love to push the rules but would like a little better sense of what coordination looks like. We might have ways of state authorities figuring that out and defining it and seeing how well that can work. I think on disclosure, some of this, like developing disclosure regulations that look through corporate entities and figure out, who the real donor is, something maybe along the lines of what Margaret was talking about in the first panel, fixing an individual who is the source of the money, if there is a kind of contribution to be tracked down and when that is. I think those types of regulatory problems could be dealt with at the state level in a way that the federal authorities have no chance of doing. I think the other thing that states might consider are, and this may not be popular in this crowd, but kind of defensive moves to protect regulation against getting thrown out by the courts on constitutional grounds. For instance, really disclosure requirements on really low-level donors. So, you can make a case that we need disclosure, and I'm all for that, but a $50 donation, maybe that's more chilling than we need. Maybe the disclosure there is not that important. We could imagine states voluntarily raising those disclosure thresholds, because what that would do is protect them against getting thrown out as unconstitutional, right? Although the Supreme Court is generally supportive of disclosure regulations, that's their push point, right? That's where they worry about individual donors who've given really small amounts having to disclose who they gave to or what they gave for, and possibly face retaliation. The court's clearly sensitive about those types of issues. You could also imagine contribution limits maybe going up, right? That sounds crazy given the amount of money that's being spent on independent expenditures, but contribution limits are really the next kind of big, issue to be fought over, and it might be smart to raise the contribution limits in anticipation of those fights.
These are very strategic thoughts, trying to figure out both the offensive and the defensive. I wanted to give you a chance, Michele, to talk about the work that you're doing here in California on
Well, this
solutions
is
that you
one of
see.
the 2016 solutions. I would touch back to a couple things. One, with the FEC, what we saw in the spring was the very clear question and indication that Jeb Bush was coordinating with his super PAC before he announced, and that this was a pretty clear violation, but that there was absolutely nothing that we could do about it. And so toothless laws, for the few laws that we have, is a very troubling thing. With regard to lobbying, there is some new thought in legal circles that the Supreme Court has not actually released an opinion, given an opinion. The cases haven't come up as to whether lobbying is actually legal or not, and to look at this within the petition clause. I don't know if you all are familiar with this, but it's actually a pretty interesting way to look at the fact that lobbying, like the kind of lobbying we citizens do, where we go and speak to our representatives, and the kind of lobbying that Jeff describes, are very different things and should be treated very differently, and that kind of lobbying should not be covered under the petition clause. And what we are doing in California, and towards a 2016 solution, this really could be quite exciting, because we, a band of us, and many of those people in that band are here today. And last year we petitioned the California legislature through every means possible, visits, hearings, faxes, phone calls, anything we could do, a march from LA to Sacramento on this issue, and did persuade the legislature to place a ballot measure on the 2014 ballot called the Overturned Citizens United Act, with very simple language: shall the people of California instruct their representatives to do X, Y, and Z towards the 28th Amendment. And literally the moment we qualified for the ballot, we were sued by the Howard Jarvis Taxpayers Association. That was a fascinating thing, because not 2 months previous, a woman whom we work with, who is a bold and brave journalist, among other things, infiltrated a Koch brothers meeting, and Mitch McConnell was asked, what are we going to do about those people who want to overturn Citizens United? And Mitch McConnell said, those people need to be stopped. And so the California Supreme Court at that time decided to order the Secretary of State to remove us from the ballot. Fortunately, we just had a hearing, and this was against their precedent. The Prop 8 had a constitutional challenge, and they decided we can't interfere with an election, and that was obviously causing a lot of harm to very real people, and I don't know where the harm would have been had we been allowed to go to the ballot in 2014. But we will, in all likelihood, be back on the ballot in 2016 at a time when there is much more energy around this issue, at a time when we have a much better story to tell because big money really did try and throw us off the ballot. Free Speech for People wrote one of the amicus briefs along with Arnold and Porter, a San Francisco firm. But perhaps my favorite line in all of the briefs was written by UC Hastings law professor Michael Salerno, who accused the Howard Jarvis Taxpayers Association of, in the absence of having any case law to support their claims that we should be thrown off the ballot, that they were employing the tactics of a squid, which was simply spraying ink all over the issue to try and obfuscate the fact that not only did the legislature have broad authority to go on the ballot, but that we, the people, have a right to instruct our representatives. And so this is a reasonably long way of saying that in 2016, what we see happening is movement building. And the way to amplify this discussion. And while Citizens United may seem like a wonky thing, and this whole conversation has been extremely wonky, nonetheless,
That's a compliment,
there
right?
you go, all over the country. We at Movi actually created a map that illustrates this. There are only 8 states in the United States of America that have not taken some action towards overturning Citizens United. And we believe really strongly, I mean, I understand Rick's statement that, the court can change, and that may be a way in which to advance more reasonable, democratic, egalitarian, fair laws that do promote social welfare and public good. But we do not want to leave that to the vicissitudes of 5 personalities, either next year or in 20 years or in 40 years, because what we've seen in this conversation is that not only do corporations not die, but they don't give up. And that if we do not settle this with an amendment, we will be facing this again and again and again. And so I would urge all Californians to join this movement, because it is something that we have to do. Or as the Princeton study, the Gillens and Page folks who wrote about the fact that we no longer are a functioning democracy, and I think this is true, and it's certainly supported. This is something we need to recapture and reaffirm and reclaim, and please join us.
As promised, this is where I come to you all and open it up for questions. So who would like to ask a question of the panel or any of the panelists? Yeah.
I have a question. Not familiar with cases, but not the specific data in all the cases. But has the court ever really looked at as you were, part of what you were saying, Michele, the real impact of this on the process? And I say that coming from Washington, D.C., and how it impacts how the legislature, the Congress functions. Whereas 20, 30 years ago, a member could come in regular order, they meet with staff, they go to hearings, they go to the floor, they spend all that time governing, and that's how you build relationships. Now, with the need for so much money, the member has to spend considerable amount of time raising money. So you can help us maybe an hour, and then you can't raise money while you're on Capitol Hill by law. So you have to leave and go to some office, and you hit the phones. And with House members, it's every 2 years, and Senate members, at least 4 to 2 years out of your 6-year term, you have to spend a considerable amount of time on that phone. As you're saying, Jeff, forget about going into the office and video. You have to call so many people. So that's one thing, the process. So that leaves very little time for actually governing and building those relationships. So if you want to know why we have a lot of polarization and why things are the way they are, that could be a contributing cause, and I don't know if the court looked at it, because if you know, as I say, antitrust law, we have those laws to protect the safety and integrity of our marketplace so that big folks cannot block entry. But if I want to run in a House race and my opponent already has $20 million, it's hard for me to gain entry in there, and so that I'm not giving voters a real choice. So that's and if wanting to have those issues been taken into account and how that affects the process that you have to spend so much time raising money, which then lends those with more money to any individual member, regardless of political party.
One thing I can say is that in the first time the Supreme Court considered the McCain-Feingold law in a case called McConnell versus Federal Election Commission, that's when Justice O'Connor was still on the court, and the court was very deferential to regulation. The court noted that there was 100,000 pages of evidence in the case, which included depositions of former senators. And what the majority said it showed was a system of ingratiation and access, that large corporations, individuals, and labor unions were giving 6 to 7 figure contributions to the political parties. In exchange, they were getting golf with the Speaker of the House, or they were getting coffee with the President. And that this kind of undue influence justified the limits on soft money and justified some of the other laws in McCain-Feingold. Justice Kennedy dissented on that point, and he said, ingratiation and access are not corruption. In Citizens United, Justice Kennedy, writing the majority opinion, quoted his own dissent and said, ingratiation and access are not corruption, and in any case, there's scant evidence of ingratiation. And he said that independent spending cannot corrupt and will not cause the people to lose confidence in the fairness of the electoral process. And what I think he must have meant by that, because he couldn't have meant that he looked at the empirical evidence, is that he had made a determination that the First Amendment costs are simply too high, and we simply have to tolerate what some people think of as corruption.
So I think the argument's been made, it's been heard by the court before. I think it's really best directed toward expenditure limits. So the idea is that candidates wouldn't be able to spend more than a certain amount, or people on their behalf wouldn't be able to spend more than a certain amount. And that the court's just never going to go there. Your argument actually fights contribution limits, right? So if what you're worried about is this arms race problem, you don't want candidates spending all their time raising money, then you should allow them to raise money in bigger chunks. Because if you're limiting them to small contributions, they have to collect more small contributions, and that's more time. And so it's not clear that arguing that you want to free up legislators to do their job really supports the case for lower limits or stronger limits. Actually might have a paradoxical effect. One of our colleagues has said contribution limits are like allowing a starving man to eat with a tiny spoon, right? Because you have to use this tiny spoon many, many times to try to feed yourself, right? If what you want to do is hasten the process and have the man spend less time eating, give him a big spoon. Right? He'll eat the same amount, but he'll do it faster, right? If you make him eat with this tiny spoon, he's got to spend a lot of time doing it.
I understand that. I agree with that, because you still would have to raise money, and all you do is give more power to the big contributors in bigger chunks. So I'm not.
Yeah. In terms of the burden, the fundraising burden, right? In terms of corruption, right? That's right.
Yeah, and I think Michael's right. If we're looking at it from a narrow, how do you get more time for the member of Congress? And one call to one billionaire is probably faster than 5,000 calls to your constituents. But I think we want to encourage the latter and not the former. So the value of the little spoon is that they're talking to regular people in getting their money, which is a very important thing in democracy, that they're talking to ordinary people. And so I think, that it does solve the time problem to allow open contribution limits. But if the goal of contribution limits is more along the lines of the political equality point that we're talking about, then the smaller spoon, the better, because that means lots and lots of conversations that have to happen with people who might give $10 or $25, which some of the public funding mechanisms, the citizen-funded elections, actually encourage for that reason. You get a match if you raise, $1,005 contributions in your district. I'm making up the hypothetical, but the point is it encourages lots of conversations with lots of people in order to trigger your campaign funds.
And the candidates who have successfully raised a lot of money from small donations are the people who have progressive appeal or popular appeal, whether it's Elizabeth Warren or Barack Obama or Bernie Sanders or whoever those people are. And they're not making phone calls to us when they go across the street, right? To make those phone calls, and the amount of time that it is not only takes them away from their function, which is to help us and to govern, but I don't see any way that in the real world it isn't obviously corrupting. You know, the whole idea of, and I've heard, you know, Justice Scalia talk about this, about, you know, is the candidate or the representative going to be more grateful? You know, this gratitude idea in the real world is very disturbing and irritating, and we know that its function is absolutely corrupt. So that's why we have, you know, a tremendous amount of energy around addressing that particular aspect of it at the root.
I understand that today some people are using hashtag corporate rights to tweet about the event. And I was thinking, this is not one of my strengths, Twitter, but I was thinking the value of the little spoon. There's some interesting ideas coming out of the panel. There was a student question in the back. Was there a hand up back there? No? Okay. Yep. To you, sir.
It's a two-part question. If Citizens United was overturned, where would we be? And the second part is, what kind of case could make its way up to the Supreme Court now and have a chance of resulting in the effective overturning of Citizens United?
Great, and I'll look to the panel for real bullet point answers to those two questions.
There is no case before this Supreme Court. The last thing you want to do is be in front of this Supreme Court. Run as fast as you can away from the Supreme Court if there's a campaign finance case.
I'll take a little different view. First, unsurprisingly, right? First question, what would it do? It depends on how it was overturned. It depends on what kind of case. It depends on if it was an amendment, what the amendment said. But essentially, it would return to us the responsibility to do the really hard thing of starting to figure out what laws should we have to limit spending or to have public funding or all the other mechanisms.
You know, if it just had, let's put at the clock. If it just hadn't, there was no case, Citizens United. Where were we then? What did McCain-Feingold give us?
Oh, so I think, so short answer, McCain-Feingold, what was overturned there was a limit within a certain time period before primary and general elections, 30 days, say, in which unions and corporations were not allowed to spend money to advocate for or against the election of a federal candidate. That was the narrow law that was struck down. That was the very modest, I'd say fairly weak law that Justice Kennedy called a ban on speech. And that's the kind of phrasing that I talk about with sort of sloppy language that leads to bad results. But I think what everyone, I'm hearing anyway up here, is talking about isn't just going back to the day before Citizens United. It's Citizens United is the end game of a mistaken experiment. And we have to go back to Buckley, reset the foundation of equality, political equality, equal citizenship, equal representation, corruption laws, give more latitude to the elected branches to enact campaign finance laws that may be different in different places, but have the court kind of step back a little bit and let us get some reasonable laws in place. Everybody wants to do that as opposed to just turning back the clock? Because it seems to me if you've got a narrow holding, really, if you could get them to undo that holding, that would be a good first step. Yeah, it would, except if it's going to take a lot of work to do that, and on January 1, 2010, the situation wasn't great. So going back to that date probably isn't
and these guys aren't going to do that.
But yeah, no, I also wanted to speak to that point, though. There are interesting cases that we could bring to the court right now that would begin the process of undermining. As I said, Citizens United is fragile. It's like it's out there with phrases and sort of assertions that don't square with facts and that don't square with reality and that don't square in many instances with the court's other lines of cases that are happening at the same time. So two promising areas, I think, are judicial elections. I don't even know if California elects judges, but lots of states do. Yeah, so California elects judges. the Supreme Court has upheld restrictions on certain activities during judicial elections because of the nature of the judicial office, a different view of a judge versus an elected representative. So to explore whether laws limiting spending or other ways of protecting the integrity and the equal representation, both in the election and in the courtroom, during judicial elections, that could be an interesting case that could take advantage of some of the sort of contradictions between the Citizens United case and Caperton and Williams-Yulee, as it's called, the two Supreme Court cases that did suggest judicial elections and judicial offices are different than political offices. And then the other one is the super PAC. I know there's a difference of opinion about whether super PACs are here to stay as long as this court is here, but the super PACs were created by a lower court, DC Circuit Court of Appeals, in a case called Speech Now. And there are some who believe, and some very prominent constitutional scholars like Larry Tribe and Larry Lessig, who believe that this Supreme Court would actually consider saying, no, that isn't what we meant in Citizens United. We did not mean to create these entities for unlimited spending called super PACs. So I think there are some possibilities.
I actually think that pursuing that strategy of trying to go after super PACs would be not only not successful, but would be counterproductive in the sense that it would give the Supreme Court an opportunity to undermine the few laws that are left, including contribution limits to candidates, for example, by imposing strict scrutiny on contribution limits, which the court flirted with the last time it decided the case of McCutcheon versus Federal Election Commission. So I really think that it's a dangerous strategy to litigate before the Supreme Court at all.
Michael Kang?
Yeah, so I think I agree with Rick on that point, and I think as law professors, we tend to find it really fun to shoot down all these arguments and say the Roberts Court would never buy this or that because we're probably right about it, and the Roberts Court won't. But having said that, I want to leaven it by saying the work that Ron and Jeff and advocates in generating these kinds of arguments is really important. And you can see that in the campaign finance law, because if you look at Kennedy's dissents, for 15 years, he was laying the foundation for what is the law today, right? And that's got to happen in the other direction. It may not be the law in 2 years or 5 years, maybe not even in 10 years, but laying down that intellectual foundation is really important because that's the basis for which law changes, right? And so I think doing that work now is really important, even if we're not very optimistic that the court's going to buy it, tomorrow or anytime soon.
Yeah, thank you. So even with some skepticism, there's definitely room for a long game here. So I think this panel, and I ask you to please join me in thanking this panel. In 10 minutes, we will have Chief Justice Leo Strine give his keynote address.
Well, it's interesting.